Well, hello everyone. Welcome to another one of our Super Series sessions. Tonight, Faheem and I are going to walk you through some of the cases relating to the cladding litigation. I'll be doing a few of them and then I'm going to pass on to Faheem, who will deal with a couple of the cases as well. But can I start with the question, what is combustible cladding? Combustible is a term that's defined in the BCA, and it's effectively a material that is determined as combustible pursuant to AS 1530.1 combustibility tests for materials. And so, as the name would suggest, there is a testing regime in the code, and if the tests result in a material that's combustible, then using that material will be a combustible. If you use it as a cladding, it will be combustible cladding. But it can refer to any combustible material used in cladding. Tonight I'm going to deal mainly with what's known as aluminium composite panels, or ACPs, although there are other types of materials, and Faheem's going to deal with one case dealing with a material called biowood. ACPs, as you probably know, they became fairly notorious after the La Crosse and the Grenfell fires, and the latter of which obviously was a tragedy that resulted in many deaths, over 70. But there have been a lot of fires both before those fires and since. The most recent one that I'm aware of was about a month ago in Valencia in Spain, which I think involved a Lucabond PE cladding. But in Australia at least, the La Crosse and the Grenfell fires caused people to stop and question why these types of materials were permitted on buildings, and particularly through the deemed satisfy pathway. And the short answer is they weren't. But that realisation, coupled with the attitude of the regulatory bodies around the country banning their use and requiring them to be removed and replaced, has sparked a lot of litigation. And that's what we're dealing with tonight. But let me start with a bit of a recap. There are two broad issues, compliance and safety, but let's start with compliance. The BCA, as a performance-based code, sets out a number of performance requirements, and in relation to fire protection, CP1 sets out a number of performance requirements that you can see on the screen now. So that's an example. There are other, obviously, performance requirements in the code as well. Those performance requirements can be met in a number of ways. One is by adopting the deemed to satisfy criteria in the design, or developing a performance solution, what used to be called an alternative solution, or a combination of the two. And for buildings that are required to be either type A or type B, and that's virtually everything over 2 stories, or in the case of a class 2, 3 or 9 over 1 story, the external cladding has to be non-combustible. If you need the reference, I haven't got a slide for it, but it's in the case of type A, it's clause 3.1. In the case of type B, it's clause 4.1 of the specification 1.1. So most developers adopted the deemed to satisfy pathway, largely because it's the cheapest and the fastest pathway to get through the system. And the two provisions that most relied on were 1.12, non-combustible materials, in particular the bond and laminate provisions. You can see that that provided an exception where combustible material was required in the circumstances where the material complied with, effectively in our case, F. The other is 2.4, where the material was used as an attachment as opposed to part of an external wall. For the reasons that we'll explain by reference to some of the authorities, the first exception, the 1.12, is no longer available, never was, and was used largely due to a misunderstanding of what the clause meant. 2.4 similarly has been the subject of some criticism in one of the cases that Faheem will deal with, and effectively, if you want to build a building with an ACP as your external cladding, you would need to develop a performance solution that demonstrates compliance with the performance requirements of the BCA. So good luck with that. Safety, just viewed on pure safety grounds, the ACPs have a fairly unique property in the sense that they exacerbate a fire by allowing it to spread both down and up. Ordinarily, as we know, fire burns up. Following the Lacrosse fire, there was a Senate inquiry, and the Director of Fire Safety, Mr. Adam Dalrymple, gave evidence to the inquiry, and he said the fire started on a balcony from an unextinguished cigarette, an innocuous type of thing, you would think. This set fire to the cladding, and the panelling itself allowed the fire to travel the full extent of the building, 23 levels, in 11 minutes. In 31 years as a firefighter, 20 as a fire safety specialist, I've never seen a fire like this in my lifetime. If you aren't aware, the core, which is the main problem with these panels, is a byproduct of petroleum byproduct. It has a calorific value of between 40 megajoules per kilogram and 46 megajoules per kilogram, and to put that into context, diesel has 43 megajoules per kilogram and petrol has 44 megajoules per kilogram. So you get the idea of the type of, or the extent of energy that's stored in these products. There was evidence at the inquiry following the Grenfell fire that described how the outer layer of the panels, and you're probably aware that the panels are largely comprised of two outer skins with a polyethylene core. The evidence described how the panels delaminated, and that allowed the combustible core, flaming, oozing combustible core, to come out, drip down and burn up. So you had flaming, oozing polyethylene dripping down, causing further fires, at the same time burning up in the usual way, so that the fire spread in both directions at once. Not to mention the laminated aluminium sheets coming off the building, causing problems for those trying to get in and deal with the fire from below. So that's the type of material we're dealing with, and so unsurprisingly there were product bans, and regulatory authorities throughout the country began requiring building owners to remove the products and replace them. That's a significant cost, and obviously that then generated a substantial amount of litigation. And that's what we're looking at tonight. So I'm going to deal with a couple of the cases, and then Faheem's going to take over. The first two I want to deal with, and they're sort of two sides of the same coin, are the two Lacrosse decisions. So there is a decision of the Court of Appeal dealing with the liability issues and so on, and then a second decision that deals with an adjustment to the apportionment. And let's deal with Lacrosse number one first. These are decisions that began in the VCAT, but were determined by a judge, and they went on appeal to the Victorian Court of Appeal. And to give you some background, the builder, L.U. Simon, was contracted on a design and construct contract, and it retained a number of consultants, a building surveyor, Gardner Group, an architect, Ellenberg Fraser, and a fire engineer, Thomas Nicholas. Early in the design phase, the fire engineer became aware that there were to be ACPs used on the two facades, or two of the facades at least, but the fire engineering reports did not address the use of the ACPs on those facades. The specification called up Alucobond ACPs, it's a well-known brand, but it provided, as is often the case, the ability for the builder to substitute with an equal material. None of the design team raised any issue with the use of ACPs on the facades. The specification, as I said, included a requirement for the replacement of, or the substitution of Alucobond for another product, and also for the architect to inspect and approve samples. And about a year after the design and construct contract was signed, the building surveyor issued a regulatory review that raised no issues about the use of the ACPs. And then finally, the architect was asked to review and inspect and approve a sample of Alucobest, which is the product ultimately used. and it initially approved the colour, which is good to know, and asked some questions about the warranty requirements that the specification required, but otherwise approved it. And on the same day, the builder provided that confirmation that the 15-year warranty that was required in the specification was provided, and so they proceeded with the substitution of Alucabest for Alucabond. The court said there's no material difference between the two products, and nothing turns on the substitution of Alucabest. So, seen in that light, nothing particularly unusual about the circumstances which gave rise to the use of the product on the building. The tribunal found that the builder was liable because it breached the implied warranties, and that each of the consultants was liable because they had failed to exercise the due care and skill that was required pursuant to their respective retainers and their common duties. So, the apportionment between the various parties in the tribunal was that 33, 25, 39, and those of you who have done the maths quickly, you'll see that you're missing 3%. The 3% was attributed to Mr. I'm not sure his name is Gubita or Jubita, the French backpacker who started the fire with his cigarette. By this time, he'd done a runner back to France, and so his 3% was left at the feet of the builder. There were 11 issues identified on appeal. All failed except one. The court found that the breach of warranty claims were non-apportionable, and so was required to deal with the claims made by the builder against the respective consultants. There's a lot of time in the judgment spent on the proper construction of the specification and the responsibilities that arise out of that, and I'm going to let you deal with that, look at that yourselves. I'm not going to deal with it today, because what is more of interest to us today, I think, is the treatment or the understanding that the court placed on the BCA provision 1.12F, which is the one I had on the screen a little while ago. The court dealt with that from paragraph 206, and they recognised that the ACPs were combustible because they couldn't pass the test in AS 1530.1, and in paragraph 220 they set out the provisions of 1.12F, well, they set out the provisions of the whole provision, but 1.12F is the relevant one for our purposes. And I've highlighted laminate and layer in the two places that it exists, because that was something that the court had particular regard to when they came to understand or determine how one should understand that provision. The building surveyor submitted that the court should effectively ignore the PE core and look only at the adhesives. And it's fair to say that that's how the industry had been looking at that clause for many, many years. They argued that the laminate meant that, or was limited to an external layer used to cover another material in the process of lamination, being the application of a protective layer to a material, rather than a single bonded product comprised of layers bonded together, or a description of each of the layers of a bonded product containing multiple layers. The Court of Appeal rejected that, agreed with the tribunal's determination of what the clause meant, but added that layer is deliberately used within the requirements of 2 and 3 of F as a component of the phrase adhesive layers, distinct from the structural elements of the material comprising the laminates which are bonded together to create the whole. So the core is one of the laminates, and you recall that one of the requirements of 1.12F Roman 1 was that each laminate be non-combustible. The core obviously is not non-combustible, it's highly combustible. And so 1.12F, despite what everyone understood to be the case, was of no protection when an owner sought to claim from a builder for using it, relying on that to get through the deemed to satisfy pathway of the code of the BCA. The court referred at 231, subparagraph 2, to the fact that everyone was doing it in reliance on what they described as the practitioner's handbook. And when you go to the footnote, it's the Building Service New South Wales, which I think was meant to be a reference to what we used to call Daughter and Sharkey, and that, as well as the annotated building regulation of Australia at the time, really had a couple of throwaway lines that simply said the clause allows these products to be used despite the fact that the clause allows the products to be used despite the fact that the core is combustible because it's part of a laminated composite product. And everyone grabbed that, and I thought it meant that you could use these products despite the core being combustible. The court said, no, that's not right. But it's surprising that such a 2 or 3 line phrase in a book like that, or in a service like that, has spawned an industry-wide use of materials without any real investigation into whether or not in fact it complied with the requirements of the code. Now that dovetails into the next issue that the court dealt with, which is of interest to us, and that is the defence under the Victorian Wrongs Act, Section 59 of the Wrongs Act, which is the equivalent of Section 50 of the Civil Liability Act in New South Wales. But you'll see that there is an important distinction between the two. The Victorian Act refers to where the court determines that the opinion is unreasonable, whereas the New South Wales Act, obviously, we're all familiar with that, considers that the opinion is irrational. I'm not going to get into a debate today about the difference between rational and unreasonable and how much of a distinction one might draw. At 244 of the Court of Appeal's first decision, the court said that unreasonableness was broader than irrational, as used in the New South Wales legislation. So having rejected the submission that the proper understanding or the proper meaning of 1.12F was, as everyone apparently thought, they went on to deal with whether or not the Section 59 defence gave the parties a way out, and they rejected the submission on 3 bases. First, they said the opinion, which is an issue, is the acceptance of the relevant practice, not the underlying rationale for the practice. They extracted a passage from the tribunal, which I think is the best explanation of what they meant, that otherwise experienced and diligent practitioners were beguiled by the long-standing and widespread but flawed practice of giving insufficient scrutiny to the rationale for that practice. The second reason it was rejected at 239 was that the question was whether the acceptance of that practice was unreasonable, that is, whether the peer professional opinion as defined was unreasonable. And then thirdly, at 240, the relevant practice was unreasonable, and by necessary implication, that its acceptance was unreasonable in the sense that it lacked a logical basis. It goes back to this assumption that everyone was doing it because no one had gone back to interrogate the basis of why it was accepted in the way that it was. So, and I said earlier that there was one issue that succeeded in the Court of Appeal, and that was the issue concerning the building surveyor's failure to identify and remedy the omission by the fire engineer in its fire engineering report because it failed to mention the use of the ACPs and whether that caused any loss. The Court of Appeal found in favour of the building surveyor on that point, and that meant it had to go back and look at the apportionment that the tribunal had attributed to the various parties and set it aside and redo the exercise. And that's the second Lacrosse decision. I can cut through that reasonably quickly. At paragraph 1, they referred to the reason why they had to go back and readdress the apportionment. At 9, they went through the relevant involvement of each of the respective consultants in their involvement in the project and their involvement in the use of the ACPs. They set out at 18 the relevant tests to determine the apportionment, and at 21, having set out the relevant considerations, and in particular the departures by each of the consultants from their respective standards of care, they left the apportionment effectively, as the tribunal did, with one minor adjustment. They went up, they increased the fire engineer's contribution from 39 to 42, reduced the building surveyors correspondingly, and left the architect as it was. And effectively all they've done is to say, because the building surveyor was not or did not cause any damage by failing to pick up the error or the failure by the engineer in not addressing the use of the ACPs, that additional 3% was moved from the building surveyor over to the fire engineer. So it's a minor adjustment, effectively. There are probably two things I think we can take away, or three things from the Lacrosse decision. One is the proper understanding of what 1.12F means, and the second is the relative responsibilities of those involved in the construction of the building. We need to be careful there, because that's a matter that's determined by the facts of the case, and different parties will have different levels of responsibility and involvement in different projects depending on the construction, the contract structure and so on. But still, it's a good indication of what the courts might do in respect of consultants involved in the types of things that these consultants were. The other thing that I haven't got in the slide there is obviously the section 50/59 issue, which is an important issue for our purposes. Next case is the owners of Strata Plan 9250 and JKN Para 1. Richard Cheney of Greenway appeared for JKN, trying to defend the trial judge's decision. It's probably not an understatement to say he did not have a very enjoyable day in court. I think the phrase was worst day ever or something to that effect. So this involved one of the many buildings that have been constructed by the now infamous Jean Nassif, whose company Top Place, as seen on TV, was the builder and JKN was the developer. The owners claimed damages for a breach of the warranty, and in particular C, which is the warranty of the work will be done in accordance with or comply with this or any other law. The any other law is the Environmental Planning and Assessment Act, which gave legal effect to the BCA. So if you fail to comply with the BCA, you're failing to comply with the EPA. Failing to comply with the EPA, you've breached the relevant warranty. It's got A there, but that should be C. 18 capital B little c. The product in this case was a Vitrabond FR, and that's, if you're familiar with the branding, Vitrabond did produce at the time a 100% PE, as did Luca Best and Luca One and others, and an FR was their less than 100% product. But it was still a product that had more than 30% by weight polyethylene, which meant that it was banned pursuant to the product bans that had been applied around the country. And obviously it's still not a combustible product because it can't comply with the relevant test in 1530.1. And as a combustible product, it can't be used as a cladding on a building that is required to have type A or type B construction, because they, as we know, have to have non-combustible facades. So the Court of Appeal recorded at 35 that it was common ground that the ACPs did not comply with the deemed to satisfy provisions because there was no evidence of a satisfactory test under 1530.1. And at 36, there was no alternative or performance solution prior to the issue of the construction certificate. The reality is that very rarely, I haven't come across any so far, will there be a performance or an alternative solution justifying the use of the panels, largely because everyone assumed they could slide it through in the deemed to satisfy provisions 112 or 2.4, as Faheem will describe in due course. So the trial judge then said, let me go back. The trial judge, it was Justice Black who determined it at trial, didn't consider that the wholesale removal, despite the non-compliance with the BCA, didn't consider that the wholesale removal and replacement was reasonable, and that the owners hadn't established that an alternative solution would not be available. He found that there was no evidence that the cladding was combustible because, just as there was no evidence that it failed a 1530.1 test, there's no evidence that it didn't fail a 1530.1 test because no one had done the test, but it's generally accepted that they are combustible products. In any event, His Honour found that there was no evidence that it was in fact combustible, and then His Honour proceeded on the basis that the owners had an onus to establish that an alternative solution could not then or now be performed. Ordinarily, a performance solution would need to be performed or produced at as part of the design, so it could be produced and submitted in order to get the construction certificate from the PCA or council. The proposition is that wholesale removal and replacement is unreasonable in the Belgrove and Eldridge type sense, because you could retrofit an alternative solution or a performance solution, thereby justifying its use, and had that been done at the time, it wouldn't have been non-compliant. That's sort of the logic. It was accepted at trial that the warranty was breached, and the real question was, did that breach give rise to the damages based on the removal and replacement of all of the cladding? And so the Court of Appeal then went through all the relevant issues by reference to the authorities dealing with reasonableness of the rectification in the Belgrove and Eldridge sense, and said at 71, the burden of proof for establishing loss lies on the claimant, in this case the Owners Corporation, and by contrast, the party in breach of contract has the onus of displacing the prima facie rule for assessing damages as the cost of reinstatement. And you'll recall that the trial judge had found that there was an onus not only of proving loss, but of disproving the ability to retrofit an alternative solution, and that was an error the Court of Appeal found. So at 81, the Court of Appeal said that having established the breach, the owners did not have to prove that an alternative solution could not then or now be performed. So although the respondent had speculated that, as defendants tend to do, that an alternative solution might be possible, and even in some cases they tend to set out the things that might be covered by an alternative solution, the court noted at 82 that the respondents did not adduce evidence which, if accepted, would have shown that an alternative solution that would satisfy the performance requirements of the BCA could have been formulated, assessed and certified prior to the issue of the construction certificate, or could now be formulated, assessed and certified. Effectively, one would need to produce the alternative solution to demonstrate it could be done, because it has to be more than just a theoretical possibility. There is an assessment and a certification requirement involved in the acceptance of it, and so you need to demonstrate that's possible by doing it. So having found that the respondents had not discharged their onus by failing to adduce that evidence, the court then considered whether the replacement cost was reasonable, and in answer to that, the respondents had said, well, there's a breach, but it's really a formal breach. It's not a substantive breach because you can retrofit this alternative solution. The court rejected that. At 106, they said there's no distinction between a formal and a substantive breach of the BCA. A breach is a breach. And at 109, it's not necessary to find that the fire will occur. It's only that they're given the non-compliance, there is a real risk of damage. And they went on to say that reasonableness, by reference to one of the other decisions, a decision of Justice Keane in the Queensland Court of Appeal, I think at the time, that reasonableness does not require the owners to carry those risks. That is the real risk of damage. So what do we take away from JKN? There's probably two important points. There's no distinction between a formal or substantive breach, as the respondents had it submitted, and the importance of who bears the onus for doing what. So that there is an onus to prove damage, then once the prima facie case is proven, if there's to be a justification for departing from that usual rule, that rectification is to be the measure of damages, the respondent has the onus to demonstrate that. And in my view, it would be very difficult to establish that, short of producing the alternative solution that you say as a defendant is able to be produced and would be assessed, certified and accepted and so on. Or formulated, assessed and certified. So in most cases, you would need to go the extra yard to do that. That's all I have to say. I think it's time for me to hand over to Faheem, who's going to deal with a couple of the more recent decisions, Taylor and Sydney City Council.
Thanks, Ian, and thank you to everyone who is attending both in person and online today. So as Ian mentioned, I'll discuss a couple of decisions. Now, the first decision I'll talk about is the decision of Taylor Construction Group Pty Ltd and Owners Starter Plan 92888. And I think as Ian has given you a bit of a teaser, this is a case that deals with the other provision, clause 2.4 of specification C 1.1 of the BCA, which is the other deemed to satisfy provision which is often being relied on to install some of these sorts of products. Now, this is, of the cases we're going to talk about, this is the only case that's not about ACP. It deals with a combustible cladding product called biowood, which is made of about approximately 70% reconstituted timber and 30% PVC. And that's really what made it combustible. Now, you can see I've taken a couple of photographs from the judgment, and it's a two multi-story residential towers in Ryde. And you can sort of see, I mean, it's not the clearest, but effectively along the side you can see there are this biowood material going up the sides. And on the other side of the building, again, in each of the balcony had sections where there was these biowood panels. Now, the key issue in this case was, is whether this biowood presented an undue risk of fire spread via the facade of the building. And I'll take you to the BCA any moment and take you through why that's the relevant question. But ultimately, the Owners Corporation commenced proceedings against the builder and the developer in NCAT in the first instance, and the senior member concluded that biowood does in fact create an undue risk of fire spread. And so he found that biowood was not fit for purpose, and by installing it, the builder and the developer had breached their statutory warranties under the Home Building Act. And ultimately, the remedy was a work order requiring the builder and developer to remove the biowood and replace them with attachments that are compliant. Now, builder and developer then appealed to the appeal panel, and then that appeal was unsuccessful. And the decision that I'll talk about is the appeal from the appeal panel decision. So the builder and developer tried their luck again and appealed to the Supreme Court, where the matter came before Justice Henry. Now, before looking at what she had to say, I'll just take you through the relevant provision of the BCA, just to give you a context as to why the undue risk question is important. Now, it's important to note that in this case, the relevant version of the BCA was the 2014 BCA. Now, it's also, I guess, important to bear in mind that since then, the BCA has actually changed. So the version of the BCA that Her Honour discusses in this provision is not the current one. But I imagine there will be certainly, it will apply to a lot of buildings, and there will be sort of cases coming through the system where the old regime still applies. So I guess it's important to note at the outset, it's important to bear in mind which provision, which BCA applies, and depending on which BCA applies, what I have to say about this decision, and more importantly, what Her Honour had to say, may or may not be as relevant. Now, Ian has introduced you to the concept of the deemed to satisfy provisions, and they can be found in Part C 1.1. And Ian has mentioned Clause 2.4 specifically, and that's what I've got up on the screen. Now, again, 2.4a contains the relevant test, and as you can see, it's a three-pronged test. There is a and the end of each of those limbs. So effectively, you've got to satisfy each of those three criterias. And the first one, so the test is a combustible material may be used as a finish or lining to a wall or roof, or in a sign, sunscreen, blind, awning, or other attachment to a building element which has the required FRL, if the material is exempted under C110 or complies with the fire hazard properties in C110. It's not located near or directly above the required exit so as to make the exit unusable. And the third requirement, which was really an issue in this case, is it does not otherwise constitute an undue risk of fire spread via the facade of the building. Now, again, unsurprisingly, the first two limbs are perhaps more, there's less room for argument. However, the undue risk test adds an element of uncertainty, so it was unsurprising that that was really what took up most of the hearing time in this case. And ultimately, what Her Honour decided is that in the context of Clause 2.4, the risk that's being referred to is the possibility of the fire spreading via the external face of the buildings. That's pretty consistent with what the ordinary meaning you would think in that context. And importantly, the parties did not dispute what the appeal panel found, which is undue in this context means unwarranted or excessive. So the question really was, how do you determine whether a risk is undue? That is, how do you determine whether a risk is excessive or unwarranted? Now, she started by noting that the BCA does not specify the particular matters that you need to have regard to in making that determination. So the determination at 141, Her Honour decided the determination as to whether the risk is undue or unwarranted or excessive involves an evaluative task that requires consideration of the circumstances and the context in which the biowood combustible cladding is used as an attachment to the external walls of the building. And that same broad test would apply, in this case it was biowood, whether it's some other form of combustible cladding. She went on to identify, I think later on, she went on to observe that this evaluative exercise will inevitably involve balancing a number of different factors and will require a degree of judgment. And she then went on to identify some of the considerations, which relevantly include things like the object of Section C of the BCA, which is to ensure safety of people from fire, the specific requirements of the BCA, which, as Ian mentioned, that the Type 1 buildings are to be constructed using non-combustible material. You have to look at the possibility of fire spread eventuating, the gravity of risk from such use, and I think it's also important to know that that was not necessarily a exhaustive list, so it's what is relevant in that determination will ultimately depend on the facts of the particular case. Some of the other items that Her Honour identified are things like ignitability of the material and the likely rate of fire spread, the location of the material, relevant safety features of the building, and so on. And I think it's also important to know that there were a couple of arguments which were raised by the developer that Her Honour rejected. Firstly, she rejected the argument, and this is at 144. She rejected the argument that the compliance of the material with AS 1530 test that Ian sort of referred to is determinative as to whether or not the material presents an undue risk, and she rejected that argument. I mean, that's a relevant factor, but that has to be weighed in with all of the other considerations. And similarly, a similar argument was if a material has what's called a low spread of flame index, again, that does not, you can't conclude from that determinatively that the material does not pose an undue risk. And the final argument that she rejected is the builder in that case ran an argument. If the material is, so if we go back to the definition, builder ran the argument that if the material is exempted under C 1.10 or complies with the fire hazard properties prescribed in C 1.10, so in other words, if the material satisfies the first limit of the test, that in itself demonstrates that there is no undue risk. I mean, I think given the way the BCA, language of the BCA, it's probably not the best point run by the builder, but in any event, Her Honour rejected that argument, and ultimately you needed to look at all three limbs. So I guess where does that take us? I should say, I mean, the Supreme Court dismissed the appeal from the appeal panel. And there were a number of other appeal grounds, you know, which go through the usual things like, you know, failure to give reasons for the decision and so on, which I won't go into. But from our point of view, I think the key takeaway really is if you're dealing with this particular version of the BCA, I mean, as Ian mentioned, it's really to demonstrate compliance is going to require a party to come up with a pretty holistic performance solution that tries to justify how it satisfies clause 2.4. And I think it's important to note, I mean, there will always be a degree of risk involved because it's one thing for someone to weigh these various different factors and identify a performance solution that works. However, I mean, there's always a risk if there's further litigation about it. Someone might weigh the factors differently and come to a different conclusion. I mentioned it briefly. Thanks. I mentioned it briefly previously. The clause 2.4 has now been amended. And I think the new language sort of takes away this undue risk test and what it says. Don't think I have a slide of it up there. But basically the new test does is it clarifies that attaching a building element must not compromise the required FRL, that is the fire resistance level of that element. So at the moment, the building has to meet the required FRL. Under the old regime, the building has to meet the required FRL, and then if you include a combustible element as an attachment, you need to satisfy the 3-limb test. Whereas under the new regime, you just need to show that it's not going to compromise the required FRL of the building. So that's really all I propose to say about that decision. The final decision I'll talk about is the decision of Owner's Strata Plan 84411 and the Council of the City of Sydney. Now, this is a little bit different from all of the decisions we have been looking at to date. It's a decision dealing with the Building Product Safety Act of 2017. And this was one of the legislative responses to, there's Grenfell Fire, the La Crosse Fire in Melbourne, and so on. So before we look at the decision, I'll just briefly give you some background to the legislation. Now, you could actually probably spend a whole seminar on this legislation, so I certainly don't propose to deal with it exhaustively, but I will take you to a couple of provisions of the legislation that are important to understand the decision. Now, so briefly, this legislation was enacted in June 2017, as I say, following the La Crosse Fire and the Grenfell Fire. And one of the things that this legislation does is empowers the Commissioner of Fair Trading to prohibit the use of a particular building product if they are satisfied on reasonable grounds that it's unsafe. And it also allows a relevant enforcement authority, which relevantly includes local councils, to issue what's called a building rectification order if they're satisfied, again on reasonable grounds, that the building is an affected building. So that's at section 20, which we'll look at a bit more closely in a minute. But as far as affected building is concerned, to simplify, affected building is defined in the legislation as a building where prohibited building product was used in the building. So separate from this building rectification order process, the legislation also has another process where the Commissioner of Fair Trading can issue a affected building notice. And the legislation expressly provides that a rectification order can be issued even if there hasn't been an affected building notice by the Commissioner of Fair Trading. So effectively there are two separate processes being contemplated, and they can happen independently or they can happen together. And it's relevant in this case. There was no affected building notice, but the local council did issue a building rectification order. Now, with that background in mind, let's have a look at section 20, which is the provision that empowers a building product rectification order to be issued. So, building product rectification order is an order that requires the owner of a building to do such things as are necessary, and I've highlighted there, to eliminate or minimize safety risk posed by the use in the building of a building product to which a building product use ban applies. And in this case, the product used was one to which a ban applied. And the order effectively used the language of the provision verbatim, so that it required the owner's corporation to eliminate or minimize the safety risk. Now, the other provision that will become important in this case is section 26. And that says, for the purposes of this part, a building is made safe if the safety risk that is posed by the use of a building product to which a building product use ban applies, as identified by the Secretary in an affected building notice. And then it says, is eliminated, or if it's not reasonably practicable to eliminate the safety risk, is minimized as far as practicable. Now, I think before we look at the Commissioner's decision, it's important to note that section 26 expressly refers to or it includes the expression as identified by the Secretary in an affected building notice. Now, just looking at that, you would think that provision is dealing with the affected building notice process, which is different from, you'll recall, the building product rectification order process. However, the council in that case argued, excuse me, well, you have to read both of those things together, and that's really what a lot of the dispute turned on, as we'll see. Now, in terms of the basic factual background, we're dealing with a development in Zetland. It's VSQ1, consisted of a series of 5 residential towers. There were some retail tenancies, car parks, so fairly typical in that respect. And the owners' corporation, in that case, what they were arguing, they did not oppose the order to remove certain parts of the combustible cladding, but their case was some parts of the combustible cladding could effectively stay, and they could implement mitigation measures which would adequately minimise the risk. And again, you'll recall in section 20, what the order requires to be done is eliminate or minimise the safety risk. So it was before Commissioner O'Neill of the Land and Environment Court, and the decision is that it was held that section 26 applies in determining whether or not there's been a compliance with the order. And as I say, that one might think that's slightly surprising, given that section 26 expressly refers to the affected building notice process. However, Commissioner O'Neill held that, well, it's not necessary for a building to be the subject of an affected building notice in order for the relevant enforcement authority to be able to make a building product rectification order. And therefore, section 26 cannot be dependent on an affected building notice being issued. I think that proposition does seem to be at odds with the language of the two provisions, which section 20 expressly says you can have a building rectification order even if there is no affected building notice, whereas section 26 tends to suggest that that's dealing only with the affected building notice. I think the other argument that was offered is to remedy a safety risk associated with an affected building, it is necessary to consider what it means when the building is made safe. And section 26 explains for the purposes of that part of the legislation when a building is made safe. And I think that's probably a fair point. So I think the key takeaway the first takeaway from this part of the decision is, I think if you're trying to work out what the appropriate scope of a building rectification order is, I think it is necessary to have regard to the test of when a building is made safe in section 26. The next part of the decision turned on what it means, what section 26 itself means. Again, just to go back to the provision. Section 26 has a test which is in the last part of that provision. The risk has to be eliminated, or if it's not reasonably practicable to eliminate the safety risk, is minimised as far as practicable. And Commissioner O'Neill held that in that case, the appellants needed to demonstrate is it's not reasonably practicable to eliminate the risk. And the option of minimising the risk only arises if you can demonstrate the risk is not reasonably practicable to eliminate. And in that case, the evidence of the owners was not really addressing that test. They were focused more on demonstrating how much of the ACP could be kept in situ without posing an undue risk. So for that reason, the Commissioner found that the risk could in fact be eliminated simply by removing the ACP. And the fact that it would merely just cost more, that did not demonstrate that it was not reasonably practicable not to eliminate the risk. And I think the second key takeaway that comes from that decision, I think, is if you are looking to appeal a building rectification order, I think the expert evidence does need to be focused, at least based on this decision, around the practicality of eliminating the risk. And typically you would do that by removing the combustible cladding product. And the focus needs to be pretty heavily on demonstrating that it's not in fact reasonably practicable to demonstrate, presumably because there's some sort of technical problem as to doing that. That's really all I propose to say. I mean, I should note, strictly speaking, Class 1 decisions by commissioners of the Land and Environment Court don't create precedent. That said, though, I think the usual practice is commissioners there will tend to follow each other's decisions. So anyone looking to appeal or run a similar appeal will have to contend with this decision. And it does seem to take a pretty restrictive view as to what is permissible in terms of complying with a building product rectification order. And I think that's all we have for you today. Does anyone either in person or online have any questions? No?
Everyone must be thirsty.
All right.
That's all. Well,
Thanks very much.